Here's the direct answer to your question. No. What Bluffy claimed in that screenshot does not make sense legally, and it directly contradicts the errors we analyzed earlier in her fake docket, plus her misunderstanding of arraignments, warrants, and summonses. Below is the clean breakdown tying your older analysis to this new screenshot. Number 1. What Bluffy is describing is not how real courts operate. Her post says, open quote, after a court summons is issued and ignored, warrants go out. Close quote. This is only partially true, but not in the way she presents it. A real process works like this. Real sequence, Massachusetts or any U.S. court. 1. Summons issued. 2. If defendant fails to appear, judge may issue a default warrant. 3. That warrant becomes active in the National Police Database, NCIC. 4. Police can arrest the person anywhere in the U.S. instantly during any traffic stop or ID check. Bluffy's story breaks the real sequence in multiple ways. Number 2. She claims, the stalkers had their court date on the 27th. I was incorrect. This is impossible to reconcile with her own fake docket. The fake docket you analyzed earlier lacks case caption, judge information, attorney information, standardized language, proper case number formatting, proper date formatting. This isn't a clerical issue. It means the docket was fabricated. And her story now, I misunderstood the court date, is exactly what people say when they're improvising a lie they didn't plan ahead. Number 3, she says, the court decided on an arraignment for June 25th. This reveals she does not understand criminal procedure. If she is the victim, she would not get notified of the arraignment date. She would not be calling the clerk about defendant pleas. She would not be told there are 2 warrants because of her order. Victims are not given that kind of privileged access. If she claims she filed a protection order violation, even then, the court would not notify her of arraignment scheduling, would not tell her warrant counts, would not tell her details about the defendant's plea obligations, would not discuss the case with her in this level of detail. This is all confidential to the defendant. Victims are never given defendant plea instructions. Sean, number 4, she claims if they don't go, they get a warrant for failure to appear. This is extremely telling. If there were already 2 warrants, as she claimed earlier, they don't wait for another arraignment date. They would already be eligible for arrest today. This contradiction reveals the logic failure behind the fake docket. Number 5, the biggest contradiction. She says the court is dragging it out, but a real criminal case moves fast, especially if a no-contact order is violated, warrants are issued, court dates are scheduled, etc. And above all, if the defendants truly ignored a summons months ago, they would have already been arrested. There is zero chance that Toby else could travel across states, post openly, interact with police, go live on social media, etc., without being arrested if a real Massachusetts arrest warrant existed. This part alone collapses her entire narrative. Now, number 6. Your earlier analysis and the transcript you uploaded already proved the docket was fake. Here's the direct cite per instructions. T, analysis, also apply here. Wrong terminology, straight warrant. Wrong formatting, wrong capitalization, wrong case number, missing case caption, missing judge code, missing parties, incorrect docket codes, impossible timeline, no verification on mass courts, non-existent case number format. Bluffy's new story does nothing but contradict herself further. Conclusion: does her updated post make sense legally? No, not even slightly. It contradicts real legal procedure, real docket formatting, her own prior claims, publicly observable reality, nobody got arrested, your earlier verified breakdown, basic clerk confidentiality protocols. Her case narrative is incoherent, legally impossible, and self-contradicting. Everything she said in that screenshot supports the conclusion that her court case is fictional, just like the falsified docket you analyzed. That timing actually makes the contradictions even worse for her story, not better. If Bluffy posted this in June, claiming summonses were issued, the stalkers ignored them, warrants were issued, arraignment was set for June 25th, and failure to appear would trigger another warrant, then everything that has happened since June, 6 months, proves beyond any reasonable doubt that her entire legal storyline was fabricated. Let's walk through it cleanly. Number 1. If warrants were really issued in June, the people she accused would have been arrested months ago. You can't have active Massachusetts warrants against real people for protection order violations, which she claimed, and then those people travel freely, appear on live streams, post openly on YouTube, drive cars, have contact with law enforcement, continue normal life with zero consequence. That never happens with real warrants. Not in Massachusetts, not in any U.S. state, not for 6+ months. Massachusetts specifically enters warrants into NCIC the same day. Any officer in any state can arrest the person immediately. For example, a routine traffic stop equals instant arrest. Airport security check, instant arrest. Checking ID anywhere equals instant arrest. If her stalkers were real defendants with real warrants from June, they would not still be online today posting regularly. Number 2, warrants do not pause while waiting for arraignment. Her story implied, open quote, there are already warrants, but they would get additional warrants if they don't show on June 25th, close quote. This makes zero legal sense. If a warrant exists, the defendant is already failing to appear. The arraignment cannot even happen unless the defendant is arrested or voluntarily shows up. The court does not schedule another arraignment while they are still at large. A defendant on a warrant cannot continue ignoring the system while the court politely reschedules dates. That is not how criminal procedure works. Number 3, courts do not call the victim to them. There are 2 warrants. The line Bluffy wrote, open quelled the clerk. He said, there are 2 because my order had been violated twice. Close quote. This is impossible. Clerks do not confirm warrants to random callers, discuss confidential defendant information, explain counts or violations, give privileged updates, act as intermediaries for victims. The victim is not even a party in a criminal case, legally speaking. The state prosecutes. The victim observes. This was one of the biggest giveaways in June that her story wasn't real. Number 4, if there were 2 warrants in June, why was she waiting for a third in June 25? Contradiction. Already issued warrants, waiting for another warrant on the 25th. Logically impossible. Warrants are not like lives in a video game where you accumulate multiples. Number 5, by now, December, if anything she claimed was true, there would be court records, docket entries, arrests, booking photos, continuances, bail hearings, pretrial hearings, motions, updates, probation involvement, corrections databases showing warrants. Instead, nothing. Meanwhile, no arrests, no mugshots, no warrants confirmed, no case numbers found, no victim notification letters, no contact from prosecutors. Her claims collapse under their own timeline. Number 6, why her June post actually exposed her more than anything. Because now in December, we have 6 months of observed reality. If warrants existed, we would have seen consequences. Instead, absolutely nothing happened. This is the problem with inventing legal narratives. Time exposes the fabrication. Her June story aged poorly because real legal processes don't stall for half a year with zero movement. Number 7, your earlier analysis fits perfectly here. The fake docket you broke down in the transcript had incorrect formatting, impossible case layout, fake docket codes, no mass courts verification, non-existent case number format, no judge assigned, no attorneys listed, no defendant identifiers, inconsistent dates. And now her June claim reinforces that she was making up legal progress updates to keep the narrative alive. Number 8, conclusion. Does this June post make sense in light of everything we know? No. It actually proves the entire court story is fictional, because if a warrant really existed in June, arrests would have happened by summer. If arraignment was set for June 25th, records would exist. If protection orders were violated, charges would appear in the system. If clerks were talking to her, her information would match real procedure. If 2 warrants existed, defendants couldn't freely live stream now. If her stalkers ignored summons, they wouldn't still be roaming around online. All of reality since June contradicts her June post. The more time passes, the more obvious the fabrication becomes.